Okay, great. Let's get started by introducing our speakers on the panel. First, we have Ann Phinney, a deputy prosecuting attorney for Clark County, Washington, who crafted the government's argument in State versus Dahl. Ann's argument successfully persuaded the appellate court that a lifetime possession ban fit the Washington state legislature's aim of reducing repeat incidents of cruelty, was proportional to and fine-tuned to meet the intentional and egregious nature of the criminal violence inflicted upon the defendant's cat, and coincided with the state's recognized ability to restrict relevant property rights in the face of criminal convictions. Next, we'll have Kathleen Wood, who is a staff attorney for the Animal Legal Defense Fund Criminal Justice Program, where she assists prosecutors, law enforcement, and legislators throughout the country to enforce and strengthen animal protection laws. Kathleen oversees the annual Animal Protection Laws Rankings Report, has been instrumental in the creation of Animal Legal Defense Fund's state-specific farmed animal cruelty prosecution guides, and represents the organization on the steering committee for the National Link Coalition. Then we'll have Will Lowrey, founder and legal counsel for Animal Partisan, a new legal advocacy organization focused on challenging unlawful conduct in animal agricultural and research. Prior to his current role, Will served as legal counsel for Animal Outlook, where he divided his time between civil litigation and undercover investigations. Will has substantial experience using private complaint mechanisms to enforce criminal animal protection laws and has engaged in numerous lawsuits against the government and industrial agriculture. Last but certainly not least, we have David Rosengard, who will be delivering our closing comments. David is a managing attorney for the Animal Legal Defense Fund's Criminal Justice Program, who works with stakeholders across the criminal justice system to pursue justice on behalf of animal victims. I should mention that I'm only sharing a selection of our speakers' wide range of accomplishments, and so I encourage you to visit the symposium's website to read their full bios. And with that, we'll turn it over to our first speaker. Ann, take it away.
Amended the statute, and it now prohibits possession of any animals, not just similar animals of the same taxonomic order. So the primary focus of his appeal was that the defendant had his own animal. He had a dog named Tig, a miniature schnauzer. Now, we had no evidence the Tig was abused or neglected, but since they are in the same taxonomic order as cats, they're carnivores, the defendant was prohibited from owning, caring for, possessing, or residing with Tig. So he had to find him a new home. The trial court noted that it would have allowed him to keep his dog if they had the discretion, but the law left no room. And so the judge said very specifically, I'm constrained by the law and the ordinary meaning and statutory definition of the meaning of these terms. So John Dahl appealed to the sentence. He didn't assign any error to the actual findings of fact. He sought reversal of the conviction on a few different grounds, but primarily he was seeking to strike the permanent prohibition on possessing similar animals, saying that was cruel punishment under this Constitution of Washington and cruel and unusual punishment under the Eighth Amendment. So the Court of Appeals took the appeal up, and when analyzing whether or not a sentencing issue is cruel and unusual or cruel under Washington Constitution, they have to find that it is grossly disproportionate to the crime for which it is imposed. So there are four factors called the Phinney analysis that the Washington courts use to determine if a sentence is grossly disproportionate. Those factors are the nature of the offense, the legislative purpose behind the statute, and the punishment the defendant would have received in other jurisdictions, and the punishment imposed for other offenses in the same jurisdiction. So we'll kind of go through all four of those and look at what the court found with regards to permanently prohibiting someone from possessing similar animals. So the nature of the offense. The court specifically looks at the seriousness of the offense in and of itself, but also as the facts of the specific case. So that definitely played a big role in this. And this is where the court quoted my brief of the respondent. And I emphasize that the purpose of the animal cruelty laws are not to protect animals as property of their owners, but to protect animals as living, feeling creatures, regardless of whether they are wild or tame. So part of the defendant's argument was that this was a stray cat that had been terrorizing the neighborhood, which in and of itself is not true. But even if it was true, the court found, the court is indicating that doesn't matter. This is the purpose of the animal cruelty laws are to protect the animals, not whether they are owned or not, but just to protect the animals themselves. And the nature of the first-degree animal cruelty, especially in light of the facts of the present case, where Dahl shot a cat in the dark from a distance and did not check whether it had survived, supported concluding that the lifetime prohibition on ownership of similar animals is proportionate to the crime of first-degree animal cruelty. The second factor is the legislative purpose. Now, the animal cruelty statute, the version chapter of 1994, indicated the legislature's desire to modernize the law on animal cruelty to more appropriately address the nature of the offense. The prohibition on animal ownership was first added to the statute in 2009. So since 2009, that statute has morphed and changed, but the primary purpose of it was to send a message to offenders. Many other states have already passed more stringent penalties for animal mistreatment, and Washington should follow suit. Throughout the years of the statute and its development, it progressed from similar animals to a lifetime prohibition on owning or possessing any animals after a conviction of animal cruelty in the first degree, or after 2 convictions of animal cruelty in the second degree. So based upon the legislature's decision to expand protections for animals time and time again, while restricting the discretion of the trial court, a lot of different, as we'll see in the next factor, a lot of different states leave it up to the trial court's discretion. The Washington state legislature has taken it out of the judge's hands and made it a mandatory sentence provision. So given that legislative purpose, the defendant's sentence was consistent with that purpose. So punishment for cruelty in other jurisdictions. So this had to do a broad research on what other states impose for a conviction of similar animal cruelty. So obviously each state has its own different animal cruelty statutes, and they provide for different acts that would qualify as cruelty in that state. So I had to do an analysis based upon what the facts of this case were and what they would be convicted of in another state based upon those facts. And then what sentencing provisions would be imposed for those convictions. So several states do have some form of mandatory ban on allowing individuals convicted of animal cruelty to possess animals, and many more have permissive bans allowing for trial court discretion. So like Maine, the court has discretion up to and including permanent relinquishment. In Virginia, there's lifetime prohibition as discretion of the court. Delaware, there's a 15-year prohibition. And Illinois, specifically, there's for a period of time the court deems reasonable. So a lot of those states do leave a lot of discretion for the trial court, while Washington has very specifically taken it out of the trial court's hands and made it a mandatory sentence. So the Court of Appeals in this case did note that while there is no other state that imposes a mandatory lifetime ban on the possession of animals, the nationwide trend has been to reduce trial court discretion and require longer prohibitions on animal ownership as a consequence of such convictions. So since the art of justice is leaning in that direction, Washington state statute is relatively close to the national norms. So they found that third factor to be in favor of the permanent prohibition. And then punishment for other offenses. This is where it gets interesting from both sides. So the defendant tried to bring in information about, the state's ability to limit parent rights. And, we obviously went more towards the direction of firearm rights. Ultimately, it boils down to the fact that pets, as a matter of law, are still considered personal property without protections for ownership. And you'll see that case name again soon. Ultimately, our laws do perceive pets as personal property, and owning a privileged animal is a privilege and not a right. So obviously, with a lot of the animal law, there's a conflict between the laws as protection for animals in and of themselves, and laws as protection for animals as property, and laws as protection as animals as property, but not as owned property. So the legislature's punishment for animal cruelty is not without nuance. The legislature took care to fine-tune the punishment for animal cruelty and allows for leniency for lesser versions of the defendant's behavior, or if the defendant presented evidence of rehabilitation. Only defendants convicted of the most severe form of animal cruelty are permanently prohibited from animal ownership. So Washington does not revoke the right to own or possess certain privileges and property items when an individual has discerned. Washington does revoke the right to possess certain privileges or property items when an individual has demonstrated a lack of regard for that privilege or property. So owning animals is a privilege. So all four Phinney factors weighed in favor of concluding that it was not disproportionate to prohibit a doll from possessing similar animals, especially given the legislature's limitation of the lifetime ban to only the worst animal cruelty offenses. The lifetime prohibition on ownership of similar animals in former RCW 1652-204B is not grossly disproportionate to the offense of animal cruelty in the first degree. Thus, the prohibition does not constitute cruel punishment or cruel and unusual punishment under the constitutions. So long story short, shoot your neighbor's cat and you don't get to keep your dog. The nationwide trend in sentencing animal cruelty convictions has been to reduce trial court discretion and require longer prohibitions on animal ownership as a consequence of such convictions. The next step in this is getting an enforcement mechanism for these permanent prohibitions that is actually effective. Unfortunately, right now, a violation of the prohibition on possessing animals. The first one is a civil penalty. The second one is a civil penalty. And then the third is a misdemeanor offense when you possess animals when you've been prohibited to do so. Unfortunately, a lot of municipalities and the state itself doesn't really have a very good enforcement mechanism of issuing those civil penalties or even tracking and getting to the point of citing with misdemeanors for possession of animals. So while the possession has been found the prohibition on possession has been found to be constitutional, the next step is to work on enforcing that prohibition so it actually has teeth, and we can prevent people who are convicted of animal cruelty in the first degree from ever possessing animals again. Thank you. And next we'll have Kathleen Wood.
Great, thank you so much. Great, let me share my screen real quick. Okay, my name is Kathleen Wood. I'm a staff attorney with the Animal Legal Defense Fund's Criminal Justice Program. And today I'm going to be talking to you about a case also in Washington, also concerning first-degree animal cruelty. So a lot of what you just heard is going to be relevant here. But here, what we're going to be focusing on is animal cruelty specifically as a crime of domestic violence. And I do want to give a bit of a warning. This presentation will contain some description of graphic animal cruelty. I won't be showing any photos or videos, but there will be a description. So please practice self-care. So as If you were here for the symposium yesterday, you heard David kind of talk about the property status and the evolution of animal cruelty law. So property status of animals has shifted over the past 150 years, starting as property rights, evolving to protect societal moral values. And now we're seeing an explicit acknowledgement of animal sentience, and that the animal cruelty laws are there specifically to protect the animals themselves. David also discussed a little bit of why this is significant, particularly for the rights of crime victims or animals as crime victims. It means that courts are recognizing that these laws are there to protect the animals simply because they matter and because they deserve protection and they're worthy of legal protection. It's also significant because crime victims have certain rights within the criminal justice system. Unfortunately, it's still pretty rare for courts to come right out and say the animal cruelty laws are there to protect the animals. In Oregon, there were 2 landmark cases decided in our state Supreme Court in 2014, Nix and Fezenden, which established animals as crime victims. And then in 2016, we have a similar case out of Colorado, People v. Harris, where the appellate court did much the same thing. And these were cases where the courts explicitly came out and said, animal cruelty is an offense that is designed to protect animals because they are sentient and they are the victims of that offense. And that is something that's pretty rare to see in modern jurisprudence. What we're just now starting to see are cases recognizing humans as also being victims of animal cruelty offenses, not because they are the property owners of those animals, but because they share a human-animal bond with their animal. And that's what's going to be coming up in the case that I'm discussing today. So this is one definition of the human-animal bond. There are many different definitions, but this is the one that I personally like. The human-animal bond has been defined as a mutually beneficial and dynamic relationship between people and animals that is influenced by behaviors essential to the health and well-being of both. This includes, among other things, emotional, psychological, and physical interactions of people, animals, and the environment. And if you want to learn more about the human-animal bond, I've linked here to the Human-Animal Bond Research Institute, and they've got some great information. Unfortunately, there's 2 sides to the human-animal bond. It can be incredibly rewarding and fulfilling, as I'm sure most of you all know, loving your companion animals. But there's also this darker side of the coin. The bond can be exploited by others who use it to threaten and control humans. The context that we most commonly see this crop up in is domestic violence. So one study found that 89% of women in domestic violence shelters who had companion animals reported that their abusive partner had threatened, harmed, or killed their companion animal. Multiple studies have consistently shown that about 1/3 of domestic violence survivors delay their escape out of fear for their companion animal, specifically because their abusive partner has threatened to harm or kill the animal if they leave. And because, unfortunately, there's a shortage of domestic violence shelters throughout the country that will permit you to bring your companion animals with you. And so often these survivors are left with no safe place to bring their pets. If you want to learn more about the link, we have a fact sheet on our website that's linked here, and also the National Link Coalition. Their website has a ton of information on the link between animal cruelty and interpersonal violence. So this all brings us to Mona, and this is the case that we're going to be discussing today. So in 2018, Julie was the guardian of a 7-year-old Chiweenie, a half dachshund, half Chihuahua named Mona. And this is not an actual picture of Mona. This is just a picture of the same breed of dog, so you can get an idea of what she looked like. Julie doted on Mona, spoiling her and taking her everywhere. She referred to Mona as her companion and her baby. Julie started dating Abdi Issa, the defendant in this case, and they dated for several months. During that time, Julie reported that he frequently became angry and hateful, and that he had threatened to kill both Julie and Mona on 2 separate occasions. Outside of Julie's presence, Abdisa had also allegedly been physically abusive to Mona at least twice. So there was one time when she left the room, and when she came back, Mona was limping, and another time she left Abdisa alone in the car with Mona. And when she returned, Mona had 2 large gashes on her head. And in both instances, Abdisa claimed that Mona had injured herself. This brings us to October 17th, 2018. The defendant and Julie were sitting in a parked car in downtown Seattle. Over Julie's objections, Abdisa took Mona for a walk so that he could, quote, bond with her. And Julie said that she felt powerless to stop him. Short time later, he calls Julie and says that Mona slipped her harness. She's disappeared. I can't find her. But then Julie hears 2 high-pitched yelps in the background. Around the same time, there's 2 passerbyers nearby who hear Mona yelping in distress. They follow the signs to the sounds to a bank parking lot where they witness Abdisa punching Mona, who's a 12-pound dog. The witness described it as a brutal stabbing motion. They said that each time he struck Mona, she made a, quote, screeching, screaming, pained, awful sound. He then began kicking Mona as hard as he could, sending Mona flying into some nearby bushes. He continued to hit Mona, and her cries went from, quote, wild, painful sounds to silence. The witnesses tried to intervene. He threatened them, saying, "Do you want some?" They then called 911, and when police arrived, they found Mona barely alive in the bushes, blinking slowly and softly whimpering. When one of the witnesses learned that Mona was still alive and still suffering, she herself suffered a panic attack. Police transported Mona to a nearby veterinary hospital, but she unfortunately died shortly after arriving, before Julie was able to reach her. The witness in this case was traumatized by what she had seen. She continued to have flashbacks in the following weeks and was triggered whenever she heard a high-pitched yelping noise that reminded her of Mona's screams. So in this case, who is the victim? Is it Mona? Is it Julie? Is it society as a whole? Or is it a victimless crime? The legal issues in this case were governed by Washington's Sentencing Reform Act, a piece of legislation that has a very specific definition of victim that's here on the screen. It defines victim as any person who has sustained emotional, psychological, physical, or financial injury to person or property as a direct result of the crime charged. Note this definition specifically uses the word person, which unfortunately excluded Mona. I'm not going to be getting into issues of legal personhood here today, but courts in Washington had just recently declined to extend legal personhood to animals in a separate case. So that was unfortunately not up for debate in this particular case. So at trial, Abdisa was convicted of animal cruelty in the first degree, which carries the maximum sentence of 12 months incarceration. The prosecution also asked for 2 different sentence enhancing factors. The first is that there was a, quote, destructive and foreseeable impact to someone other than the victim. And the jury found that there was indeed such an impact in this case because of the witness who was traumatized at the crime scene, and held that she had sustained a destructive and foreseeable impact, and applied the enhancement, leading the defendant's incarceration period to be extended by 6 months for a total of 18 months. The second sentence enhancing factor that the prosecution requested for this crime was that the crime manifested deliberate cruelty or intimidation of the victim. The jury declined to apply this factor. We don't know specifically their reasoning for it. I suspect that it's because Julie was not directly present, didn't directly witness what happened to Mona. And so maybe that's why they felt that there wasn't deliberate cruelty or intimidation to Julie, but that's just my speculation. The trial court also, the jury also assigned a domestic violence designation to this conviction. So this designation, it's not an additional charge or crime. It's just kind of a tag or classification added onto the cruelty conviction, flagging it as a crime of domestic violence. Domestic violence designations are intended to ensure that these I'm sorry if you can hear my cat Penny. She's behind me on the windowsill. She's just woken up from her nap. Domestic violence designations are intended to ensure that these cases are taken seriously and that the victims in this case receive, quote, the maximum protection from abuse which the law can provide. Here, this specific designation allowed the court to give Julie a protection order preventing Avdisa from approaching or contacting her. Avdisa went on to appeal this decision. He argued on appeal that animal cruelty was a victimless crime and that therefore the sentence enhancement and domestic violence designation were inapplicable. The appellate court agreed with Avdisa. They said that there was no victim in this case for the purpose of the Sentencing Reform Act. Because Mona is a dog, they held that she cannot qualify as a victim, which is unfortunate, but is, legally sound given the limits of the existing statute. When asked whether Julie was a victim of this crime, they kind of went through this set of legal and mental gymnastics. They determined that Julie was the, quote, ultimate target of the offense, but they said that, animal cruelty law is there to protect animals, not humans. They cited the evolution of animal cruelty law that we mentioned before. The animal cruelty laws apply regardless of whether a person owns the animal. So obviously it's not a traditional property crime where the owner is the victim. But since they had already decided that Mona couldn't be the victim either because she wasn't a person, they instead said that she was, quote, the object of the offense. So here we have a target and an object of the crime, but no victim. And then this is the part of the opinion that really had me facepalming when I read it. The appellate court acknowledged that Julie had a property interest in Mona, because the state, alternatively tried to argue that Julie was a victim because Mona was her property and her property had been damaged in this crime. The court said, well, I see that you have a property interest in your animal, but if you wanted to position Julie as a victim, you should have charged the defendant with malicious mischief, which is Washington's law prohibiting destruction of personal property, because that crime is specifically intended to protect property owners. Animal cruelty, not so much. That's intended to protect animals. So really, you might have been the victim of malicious mischief, but you're not the victim of animal cruelty. And that degree of mental gymnastics was what really had me interested in this case and wanting to make sure that there was better language on appeal. So because there was no victim and the sentence enhancing factor was found to be inapplicable, and also because there was no victim, they ruled that animal cruelty was not a crime of domestic violence. So this fortunately gets appealed to the Washington Supreme Court. ALDF, actually David and I submitted an amicus curiae brief or friend of the court brief, because as David said in his presentation, we're lawyers and we like using Latin to make ourselves sound more important. We had 3 specific goals when filing this brief. One, we wanted to make sure that the court acknowledged the human-animal bond and the psychological impacts that this crime had on Julie because of that bond. She was a victim not just because Mona was her property, but because Mona was her companion. And then 2, we wanted the court to acknowledge the link between animal cruelty and recognize that animal cruelty can be a crime of domestic violence. And we know from the research that this happens way too often. And 3rd, we wanted to kind of play defense. So in our line of work, we've seen how damning it can be to have case law, even non-binding dicta that is out there by the highest court in the land saying that without nuance, animal cruelty is a victimless crime. So we wanted to make sure that the court was really aware of the weight that their words had in this context. Because even though Mona was not considered a victim for the purposes of the Sentence Reform Act, that didn't necessarily mean she could not be considered a crime victim in other contexts, like common law issues that might arise in other cruelty cases down the road. So fortunately, the court agreed with our analysis on all 3 points. They specifically cited some of the research on the link that we had included in our brief, which was really exciting to see in the final opinion. And they cited this when holding that Julie was a victim and that animal cruelty can be a crime of domestic violence. The court was also really cognizant of the importance of the term victim in their opinion and was very careful about how they used that term. This made this particular section all the more exciting to me. So here the court's discussing how on this appeal, Abdiisa was actually arguing that Mona was the quote victim, not the term of art, capital V victim for the Sentence Reform Act, but kind of in the sense of the way that the appellate court was using the term, that she was the object of the crime. So anyways, they're noting that in the appeal, the defendant or respondent had argued that Mona was the victim. And they respond by saying, as explained above, Fairbanks or Julie is also a crime of the animal cruelty charge. And it's the use of the word also that I think kind of also implicitly implies that Mona was a crime victim as well. Again, not necessarily in the technical term of art sense of the word under the Sentencing Reform Act, but in the sense that she was an individual, a being, a party who was harmed in this offense. There was also a concurrence and a partial dissent in this case. Essentially, some of the judges argued that the sentence enhancement factor shouldn't have applied because the harm to the witness was not foreseeable. They were saying that would mean that, any crime committed in public could result in a sentence enhancing factor because you never know who could be walking by and witness your crime. That's not an issue that we addressed in our amicus brief. It wasn't one of the ones that we were focused on. The only reason that I bring it up here is because in that concurring opinion, we get this great footnote that specifically addresses the property status of animals that says, I do not believe this characterization of pets as personal property is necessary to the majority's analysis of the crime of animal cruelty as a crime of domestic violence. I do not read the majority to reject other arguments about the legal status of animal companions more generally. So again, it's just really gratifying to see a court being so careful about the weight of their words and preserving future arguments for animal victimhood in other cases. And then finally, we have a piece of legislation that passed last year, partly in response to this case, that created a new definition of coercive control in the domestic violence statutes. And this specifically includes threats or harm to animals as a means of coercive control, which then is included in the definition of domestic violence. And so there has been a little bit of movement on that front legislatively. And that's it. So thank you very much. And now I'm going to be turning it over to Will Lowrey to discuss his case out of Pennsylvania.
Thank you very much, Kathleen, and thank you to Anne and ALDF. Let's shift over here. Okay, so we've talked a lot about companion animals. I'm going to take a little bit of a shift and talk about animals used in agriculture for this part of the presentation. And so my name is Will Lowrey. I'm the founder and legal counsel for a new group called Animal Partisan. The case that I'm going to talk about today was a case that I did with the prior organization, Animal Outlook. So I want to make sure that that credit is given. And just before I jump into the first slide, we've seen in the prior two presentations some of the difficulties with prosecution and enforcing the law, even as it relates to companion animals. It is even harder when it comes to animals used in agriculture. And that's sort of the overarching theme of today's presentation. And we'll talk about trying to tackle some of those obstacles with one specific case in Pennsylvania. So there's a lot of reasons, just more broadly, before I get into the specific case. From talking to prosecutors, sheriffs, law enforcement all across the country, there's a lot of different reasons that are given why people do not want to prosecute cases involving animals in agriculture. And I'm talking cattle and chickens and pigs and even fish in aquaculture facilities. Some of it gets into just a plain misunderstanding of the law, and that could be believing that, I had a sheriff in California tell me that cows were not covered in the law, which was not true. Some of it could be the mental state required. Some of it could be the exemptions, which we'll talk about in more detail as I get into the presentation. And then there's others, I would say, sort of less legal reasons that are given, just lack of experience, resources, political and local pressure is a big one. If I am a prosecutor in a small rural town, a lot of them don't want to be the ones to go out on a ledge and prosecute sort of the big factory farm in the area. And then there's other ones you can expect, just distrusting animal rights organizations, or just flat out not believing that these animals deserve any sort of protection. So that's kind of the overarching theme, is to start with this point that it's very, very difficult to get prosecutors across the country and law enforcement to buy into these prosecutions. But fortunately, well, I'd say a few things. Fortunately, there are some, and there are some across the country, and I don't want to paint with too broad of a brush, that will take these prosecutions and will pursue them. But what has sort of come up for some of us trying to get these prosecutions as a bit of a workaround are these criminal procedural mechanisms that exist in a number of different states. And I think there's probably 20 to 25 different states that have mechanisms where private parties or an organization like Animal Outlook in this specific case can try to figure out a way to get around a sheriff or a prosecutor who may be reluctant to prosecute. And in a lot of these states, the case law is very, very limited. What I mean by that is that they're not used a lot. There may be something on the books, but nobody's really used it. That wasn't the case in Pennsylvania, which is what we'll talk about today. Nobody had really used the statute from an animal cruelty perspective, but it had been used in many other contexts, police shootings, simple assaults, those types of things. And so the procedures that exist vary by state, and you'd probably be surprised at some of these options that exist. And this is not to say that they're easy or anybody can do them, but there are vehicles that exist. And in some cases, if you go to a prosecutor and they deny a charge, you can ask a court to review that decision, which is what we'll talk about in Pennsylvania. Other cases, you can go to a magistrate, which is a lower level judicial official, or straight to a judge. New Jersey, for example, I had a case where I went straight to a judge on a low level animal cruelty offense. In other states, you can request to appear before a grand jury, actually approach the foreperson and ask to appear before the grand jury. Some states you can appoint a private prosecutor, and then there's always the writ of mandamus, which rarely works. So the takeaway from this is lots of procedural avenues, and now we're going to dive deep into one in Pennsylvania. So again, this is an Animal Outlook case. This was or stemmed from an undercover investigation at a dairy farm in South Central Pennsylvania in 2018. So this was an industrial dairy farm with about 1,000 cows. And so we are talking a dairy factory farm in South Central Pennsylvania. Animal Outlook had an undercover investigator that worked there for a period of probably 2 to 2.5 months. And that individual documented through written notes as well as through video a number of different instances. And when I say a number, I'm downplaying it. I'm talking hours and hours of footage of just egregious cruelty and neglect. And I won't read through the whole list, but this includes hitting and kicking, just improper euthanasia, a lot of dragging down cows. So these are cows that can't stand or walk, and now they're being pushed with tractors or lifted up with this hip clamp device from a bucket on a tractor, twisting of tails, just improper veterinary care, all of the stuff that you would probably expect from a dairy that has 1,000 cows. And so that information was documented, like I said, in written notes as well as video. And Animal Outlook at that time approached the Pennsylvania State Police and asked for animal cruelty charges, and not just against individual workers, but against the owners of the farm, against the farm itself as a corporation, and provided almost 100 pages of documents, 4 hours of video. You can sort of read through the notes, the farms in the second bullet there, sort of the agriculture industry issues your typical statements about being appalled and that this is willful mistreatment. That's kind of the MO when these types of investigations come out, is for the agriculture industry to say, gosh, this is horrible. These are bad apples. We don't support and condone that. And yet it happens over and over again. And so after over a year, you could see from January 2019 to March 2020, Pennsylvania State Police were presumably investigating this case and then ultimately issued a press release. That's how we came to find out that the charges were declined, was via a press release saying that prosecution was declined. They visited the farm. There was really no other explanation given beyond that. And so now we get into Pennsylvania's somewhat unique procedural avenue. It's this section 506 of Pennsylvania Code. You obviously don't have to review it all, but there's a couple of bold-faced sections that I wanted to point out. The first one in subsection A, when the affiant is not a law enforcement officer. So this is explicitly stating that it does not have to be a law enforcement officer who brings this complaint. It's opening the door to private citizens, organizations, and others who may not be your typical channel to bring a complaint to a prosecutor. And it allows that individual to bring the complaint. And then second, what's also important here, we'll get into this in a few slides, is the last bold-faced section, which is if the district attorney disapproves the complaint, the affiant may petition the Court of Common Pleas for review. So this is a critical step. And what this is essentially saying is that if you go to a district attorney and you have to be law enforcement to do that, they deny your complaint, you can then petition a court for an appeal. And so that gives sort of the proverbial multiple bites at the apple. And you can probably figure out what happened next. And so Animal Outlook, after that decline, and again, that first decline was from the Pennsylvania State Police, went to the district attorney, submitted these private complaints asking for 327 individual charges. I know because I wrote out the forms asking for 327 charges, and we submitted it to the district attorney asking for criminal charges, and it was denied. And I know you can't read the letter on the right, but the point is there's not much to read because the letter basically says decline for, quote, lack of merit, and that was it. Like that was it. So now we're at the state police have declined, the district attorney has declined. And now, if you remember subsection 2 here, after the district attorney declines, what can you do? You can petition the Court of Common Pleas. And that's exactly what Animal Outlook did. And so now, if you're keeping count, we are on attempt number 3 to get criminal charges, despite possessing hours of video evidence, documentation, et cetera, et cetera. And so now we've gone to the Court of Common Pleas, and that happened via a petition that was filed in September of 2020. For the non-attorneys on here, this may not be interesting, but there's this concept called the standard of review, which will become very important later. And it's really a question of like, how much deference does the trial court give to the district attorney in their decision? And ultimately, we received a favorable ruling here. We got a de novo standard of review, which means that the trial court will look at it with no deference to the district attorney. And so they did, and that was great. And that was a small victory to start with. Unfortunately, even after doing that, the trial court said no criminal charges here, nothing to see, no animal cruelty, issued this 13-page opinion in February of 2021. And you can see this sort of short statement at the end. There was not enough evidence based upon the law to initiate prosecution against any of the defendants. And so here we have a situation where we have documented 327 incidents over approximately 3 months against animals in agriculture. And we have now been told by the Pennsylvania State Police, the district attorney, and the trial court that not a single one of those 327 incidents amounted to animal cruelty or neglect under Pennsylvania law. Kind of hard to believe. So what do we do then? We appeal. And so now we're on attempt number 4. And so we appealed this case to the Superior Court, which is one of 2 appellate courts in the state of Pennsylvania. And essentially we are appealing the trial court's decision. We're saying that the trial court made an error when they said there was no cruelty or neglect here. You can read the arguments there. I won't go through those in any detail. But we believe that they had made multiple errors of law in doing so. And we specifically highlighted 3 categories of incidents amongst the 327 that we felt we had the strongest legal case for. And those include improper disbudding, which is, if you're a young calf in a dairy industry, and the farm does not want you to have horns. In many cases, they will use a hot iron to burn those horns off. In this case with Martin Farms, that was done when the calves were much older than they should have been, such that the horn buds had attached to their skull. There was no pain medication used, and they were improperly handled. So we felt like we had a pretty strong legal argument against that. The handling of non-ambulatory cows, these are the downed cows that couldn't stand or walk, that were being pushed around. And then just the general failure to provide veterinary care. So those were the ones that we called out. And so you can probably guess what happened, because if we lost, we may not be presenting here. But let me, before I get into that, talk a little bit about this normal agricultural operation exemption. And so I think a lot of folks in this call are probably familiar with it, but just if for those that are not, or maybe even those that are, every state has an animal cruelty law in some form. In many of those states, and I think it was probably 35 or 37 the last time I looked, there is what's called a normal agricultural operation exemption. Some states call it common animal husbandry, agricultural practices. Pick whatever definition you want to use or whatever terminology. But what it essentially means is that, hey, here's an act that if this were committed against a dog or a cat, this may be cruelty. But if this is done in the normal course of agriculture, or it's part of a standard farming practice or some other language, it is not cruelty. And Pennsylvania has its own form of that, which they word as the normal agricultural operation exemption. And I won't read the whole definition, but you can see it. There's a few key words here. The first one is normal activities, practices, and procedures. You can also see year after year in the third line down, which means it's sort of repeating. It's not something that happens once. And it's during the practice of, preparing for market, poultry, livestock, et cetera, et cetera. So that's a pretty important point as we move into the last few slides here. And as I said, we got a favorable Superior Court decision, fortunately. So now on our fourth attempt, we went to the Superior Court. The Superior Court said, yes, I buy it. This is animal cruelty. And the court ultimately remanded the case to the trial court and sent it back to the trial court and said, trial court, you got it wrong. You need to order the district attorney to prosecute these people, this owner, this company, for these categories of incidents. And so we didn't argue all 327. So there's some subset of incidents, probably in the several dozens if I have to count. But the court decided that the movement of the down cows, excessive shocking, pulling and twisting tails, the dehorning, the disbudding. But the interesting part is not so much like the what they did, but it's why they did that and how they got there and what's important about the outcome here. And so they found that the trial court erred in a number of different ways. One is that they credited Martin Farms veterinarian and they dismissed a lot of our evidence. So if you were to read the 13-page trial court opinion, you would see a lot of crediting Martin Farms owner, Martin Farms veterinarian. Martin Farms, by the way, is the factory farm, if I didn't mention that, crediting their owner, their veterinarian, their workers, people that have come and trained them, but completely dismissing veterinary experts that Animal Outlook provided, completely dismissing the videotape. They also accepted remedial measures as negation of liability. And what I mean is the trial court said, to some extent, okay, the farm's done things, they've changed practices, they fixed it, it won't happen again, so therefore there's no cruelty. And the law doesn't really work like that. And the Superior Court sort of called that out. And I said, I think they used an analogy along the lines of, that's no different than if a drug dealer decided to stop selling drugs. That doesn't absolve them from all of the drug transactions they sold prior to that. So that was the analogy given. And then the trial court also, and these are the words of the Superior Court, they handpicked a few of the allegations that they could properly say, this wasn't cruelty, this wasn't neglect. So this very selective, decision-making by the trial court was kind of put on display by the Superior Court. And one of my favorite parts of the opinion was when they called the district attorney's interpretation of that exemption absurd. And the district attorney had probably a dozen different arguments for that exemption, one of which said, if any farm does it at any point, it's a normal agricultural operation exemption, which means that any farm could act as cruelly as they wanted, and it would be basically immune to prosecution. And the Superior Court said that was absurd. So last couple of slides here, I put attempt number 5 question mark. I would love to have sort of stopped this on a happy ending and said, this is it. Unfortunately, the district attorney has petitioned the Supreme Court of Pennsylvania to hear an appeal. I won't get into too much detail here, but that petition was placed on hold pending the outcome of another completely unrelated case that dealt with a legal issue that's relevant in our case. And the best that I can explain it, if you remember earlier, I said, how much deference does the court give to the prosecutor? Well, that's called the standard of review. Lo and behold, the Supreme Court came back and made a new rule and said that it's going to be a lot harder to overturn a denial of a private complaint. And so what this means is that there has been new law established in Pennsylvania that is very, very unfavorable to this case. We're not sure what's going to happen yet. Time will tell. We're still waiting on an opinion for this case, but we will see. We may have to go back to the trial court and re-argue it again. So unfortunately, not the end of the road, probably. So key takeaways from this case, this case is one specific case, but I think it's emblematic of a lot of larger issues as it relates to prosecuting cases with animals in agriculture. And I hear a lot of people say that they are completely excluded from these laws. And I'll be honest, it's a little bit frustrating. That is not the case. I think a lot of people are ready to just throw away the animal cruelty laws when it comes to chickens and turkeys and pigs and fish and sheep. But that's not the case. I think there is some utility to those laws. You just kind of got to thread the needle, and that's what happened here. Another point is that practices that are common in agriculture can still be criminal. The disbudding that happened here happens over and over and over again, but that was one of the items that the court found most subject to the cruelty law. So that's not to say that just because it happens, it should not be criminal. The remedial measures that I talked about earlier, just because somebody says that was horrible, I've retrained people, I've fired them, that doesn't negate prior criminal conduct, and the court saw that here. There's this fourth point about agriculture industry testimony does not carry more weight than contrary voices. So just because you're a veterinarian or on a farm, that doesn't mean that you can sort of supersede video evidence showing otherwise. And then lastly, these private complaints have some promise. I've had success in another case in Pennsylvania. I have a criminal trial pending against a corporation, actually. I've had success in New Jersey, and there are statutes in other states that I think hold some promise to get around reluctant prosecutors and district attorneys. And that is it. So thank you. And I'm going to turn it back over to Kate now.
Thank you so much, Will, and thank you so much to all of our speakers. We'll now turn to our Q&A portion of the session. So if you do have a question, I invite you to submit your question to the Q&A chat box, which is down at the bottom of your screen. We'll turn to our first question. This is a question for Kathleen. Was the person who committed the crime to Mona out of custody the whole time during appeal? Appeal?
Yeah, so not initially, because when the appellate court reversed the trial court's decision, they still upheld the original conviction with that 12-month incarcerational period. What they reversed was the extra 6 months plus the domestic violence designation with protection order. So as far as I'm aware, he was still incarcerated for a period of time, maybe not the entire 12 months, but and then it did take a good 3 years for the case to make its way all the way to the Supreme Court. So at first, a good chunk of that period, he was released.
Great, thank you, Kathleen. We actually have another question for you. It's a multi-part. Did you say that the third party witness was emotionally affected from observing the abuse inflicted on Mona? What remedies did that party have? And would Washington State IIED intentional infliction of emotional distress or tort laws for a negligent infliction of emotional distress be changed?
Yeah, so the witness in this case was severely affected. She did seek psychiatric therapy after this incident because she was traumatized by what she had seen and heard. I don't think that there are really any legal remedies available to her. She wasn't a victim in this case. And as far as intentional infliction of emotional distress or negligent infliction of emotional distress, those have really only been applied first very sparingly across the country when it comes to animal cruelty cases. And in those cases, when it is applied, it's exclusively when the victim or the person who witnesses it is the animal's owner or has a close emotional bond with the animal. So because she was a stranger and didn't have that emotional bond with Mona, I don't see that that would be a viable legal remedy, unfortunately.
Just to jump in on that, part of what's going on with reckless negligence infliction of emotional distress is you can't recover if you are suffering emotional distress because you saw someone injured. You typically can't recover if the person you saw injured, the being you saw injured, is human. It needs to be a specific close family member. And I think if you can't recover for your best friend, for your cousin, for your aunt, the odds of courts expanding that to animals that specifically aren't even your companion animal is pretty unlikely. So I think Kathleen's answer is absolutely on point there.
Great. We have another question from someone who's asking, how do I find out, or where do I start to find out if our state, for example, California, has a private complaint prosecution code?
Well, I know California does. I mean, who's asking, it's California Penal Code 599A, allows an individual to go to a magistrate and ask for criminal charges. I would say that in my experience using that statute in Virginia and North Carolina, which is very similar, it's a tough road. I mean, a magistrate is a low-level judicial official. They're not really looking to handle complicated cases, but California is 599A in the Penal Code. There's a good resource if you Google like 50 state survey of private prosecutions that Lewis and Clark did many years ago. If you're in another state, you can look there.
Yeah, a lot of this private prosecution legal groundwork comes out of the crime victim rights movement, because as you can imagine, those are often the parties that are like, hey, I wanted that case prosecuted. And so looking in that area can get you some of these answers. The other thing to look at with California, for example, is there are some states that will specifically say SPCAs or humane societies have standing to bring a complaint.
We have another question. Which state has the most progressive animal cruelty laws concerning farm animals, or do any?
I mean, David or somebody else can chime in. I mean, I feel like I can tell you the ones where it's the least progressive, because that's where I bang my head against the wall. I don't know that I'd be willing to go out on a limb and say the most progressive. I'd probably kick that to David or one of the LDF folks.
Yeah, so I oversee our annual rankings report that looks at all animals, not just farmed animals. From what I've seen of state codes, so as Will said, most states, I think around 40 of them have, if you're including exemptions and bestiality laws, have some kind of accepted animal husbandry practice exemption. So the vast majority of them have that very broad and vague exemption. And then the ones that don't have an even more vague exemption built into the elements of their cruelty law, which is, unjustifiable or unnecessary cruelty. And that can mean whatever the 12 jurors want it to mean, really. But if you're looking specifically at farmed animals, I mean, we do see California, Massachusetts, and a few other states enacting these cruel confinement laws that ban gestation crates and battery cages and veal crates. And so, I mean, I would say that those are some of the more progressive ones when it comes to farmed animals, because they do have these affirmative, specific enforceable protections.
And I would just emphasize real quick, I mean, there's a huge difference between something written down in the law and what actually happens from an enforcement perspective. And we could have the greatest law in the world, and that doesn't mean anybody's going to do anything. I'm thinking of like California and Minnesota that don't have exemptions. I mean, I've had as difficult arguments with prosecutors in those states as any others. So I would say it's good not to be complacent that like because the law's in the books that means something. There's still the whole enforcement aspect.
Yeah, and to both of the points that you each are making, I think it's important to remember that every state in the country has some kind of exemption, and at some level, it's a matter of policy preference, which kind you like. California, for example, people will often say California doesn't have an exemption. That's because, as Kathleen said, they build it into the element. So Will's absolutely correct. They don't have an explicit exemption. They have this unnecessary, unjustifiable language, and no one really knows what that means because it's up to 12 jurors. Whether you would rather have that or you would rather have the law saying, these are the dozen things it's lawful to do to an animal on a farm, at some level, that's up to what you believe is better in terms of how you construct laws. I get nervous when we're just saying it's whatever a human can justify, because that's not justify in terms of legal defense of justifiability. That's just, as a clever primate, what can a human decide is justifiable? And that's not clear enough for me in terms of letting us know what can and can't happen. But I do know there are people who feel otherwise.
Yeah, I mean, those vague exemptions can leave room for some flexibility, to establish positive case law. If you do get a positive jury who looks at the facts of a case and goes, oh my God, this is horrible. How could you ever justify this? Of course, this is not justifiable. If it goes up on appeal and is getting affirmed that way, then, I mean, that could be positive. It could be establishing positive case law. But I wouldn't say that that's necessarily the best drafting strategy or the best drafting position.
And the optimistic flip side to what we're talking about is hearkening back to a really key point Will made during his session, which is, yes, there may be exemptions in every state, but there also is no state where you get to lawfully do whatever you want to a farmed animal, to an animal in a research facility, and so forth. We can talk about whether the protection that animals get is broad enough or deep enough, but it exists, and these animals are protected throughout the country. So if someone says to you, well, you just can't prosecute farmed animal cases, I refer them to Will's session because that person is wrong.
I think we have time for about one more question. Have there been any studies, papers, research looking at why prosecutors are reluctant to prosecute cases of animal cruelty, particularly in the context of offenses taking place on farms?
I am not aware. I mean, honestly, I've anecdotally been keeping my own notes, but I'm not aware. I would love to see it. It really is a mixed bag. I mean, I had a list at one point of 16 or 17 different reasons that were given, and it's I couldn't point you to one. Like if it were a pie chart, I wouldn't say 45% of the pie is this one issue. It just kind of depends on what they have going on, where they are jurisdictionally, what the law says. It's almost like a menu of like, hey, today I want to offer this excuse, and this excuse. Anecdotally, it seems like it could run the spectrum, but I'm not aware of like a study. I don't know, maybe somebody else is.
I'm not aware of any
kind
study.
of study.
Yeah, go ahead,
Yeah,
Kathleen.
anecdotally, yeah, we've heard a lot of different reasons, but nothing statistical.
I imagine one of the difficulties in doing a study, and Anne could probably speak to this better than any of us, is as a public official, prosecutors don't necessarily get to just talk about everything that goes on in their cases all the time. So there are probably limits on what data you can get. Yeah.
That is very much correct. And, I take a little offense at the excuses, but I mean, there are a lot of reasons. I take all of the animal cruelty cases in my office. But when you're, in a small office like I was in Grace Harbor, you have maybe 6 attorneys for an entire county. There isn't the bandwidth for big, complicated cases. So a position like Jake Kamens, who, can go to these rural counties in Oregon and help prosecute these cases, is definitely something we should strive for in every state, because it really does come down to resources, office policies, and honestly, the individual prosecutor and what bandwidth they have to apply to it.
Yeah. And to underscore that, it's important to remember that when we're talking about large farming operations, we are generally talking about rural jurisdictions, and those tend to be the least resourced prosecutor offices. And if you've got a small staff with maybe half a dozen attorneys, and you don't have the money to hire forensic experts, it can be hard to justify to your community why you're doing this case with 50 sheep or 50 cows versus a human sexual assault, a human murder. And there are answers to that. As Ann said, your jurisdiction could have a special prosecutor. You can come to ALDF or other organizations for grant funding. But there are legitimate barriers that make it harder to do these cases. For example, you need someone to testify about the condition of horses, pigs, cows, sheep, etc. The veterinarian locally probably works for the farm you're prosecuting. So now you need money to find someone who is not local, who can come in and do that. And if you are a tiny office without funds, that can become a really critical barrier.
Thank you so much. Oh, I'm sorry. Well, I'm looking at the time, and it's looking like we only have a couple minutes left in the session, but I'm seeing so many more great questions roll in. So please copy and paste those questions into an email to us at events@aldf.org, and we'd be happy to address any of the questions that you may have arising from the session. And please consider looking at the answered questions that our speakers answered during the session. There were some great questions answered that our panelists took time. I'm going to turn it over very quickly to David Rosengard, who's going to be delivering a few closing comments before we end.
Thank you, Kate. And thank you, everybody, for joining us. Just to give you a few proverbial housekeeping issues. You'll be getting a feedback survey at the end of this whole experience. Please do fill that out. We take that really seriously. It helps us inform future symposia. Also, in terms of CLEs, you should be getting that material. If you run into any issues, email us at events@aldf.org. That is also where you send any further questions you have. They'll get farmed out to the appropriate person. We will answer them. And if you had a good time with this and are wishing, wow, it'd be great to spend 2.5 days doing this in person, we have an animal law conference for you. It is happening October 20th through 22nd. This year it will be in Los Angeles. So all of that out of the way, I just want to comment on a few themes that I saw coming up over today and yesterday. And that's really how, when we're looking at the importance of criminal law in protecting the lives of animals and advancing their legal interests, part of it is we're looking at that as the practical backstop, because ultimately at the end of the line, we use criminal law to ensure that individuals are protected in our society. Part of it's also about the theoretical position of animals as someone and as being important. And I think one of the neat things about all of our sessions is they unite that theory and that practice. And we've got the Collaborative Response Project session looking at early intervention and prevention. How do we help animals by getting into things before they become criminal, or when they do become criminal, by getting a good resolution quickly. The CAP advocate session from Jessica Rubin and Tara Cooley looks at how having an attorney for an animal victim separate from prosecution and defense can cause empiric changes for the benefit of animals. And I think it's important that we bear in mind that the goal that we're talking about through this entire symposium is really, how do we make this system work the best for the animal? There may be things that we individually would like to see in terms of outcomes that are additional to that, but specifically for the animal, we see important changes coming out of that program. Similarly, Jill Hollander and I talked about various sentencing options, focusing on the needs of animals, as well as how animals, because of their unique nature, can have positive impacts on humans. And then finally, of course, we wrapped up with this excellent case study session on looking at Anne's work around State versus Dahl and how animal protection law is fundamentally for animals, whether you are farmed, wild, companion, feral, or otherwise. And that in fact, that kind of protective sentencing can apply to perma-banning someone from having animals. We heard from Kathleen about Abdi Isa, the human-animal bond, the importance of victim questions. And then finally, Will's excellent work around private prosecutorial complaints out of Pennsylvania, and that having a really important truth-telling and transparency function. At the end of the day, we elect prosecutors and we elect them to make hard choices about what they're going to prosecute and not prosecute. They should be honest with their communities about why they're doing something. If they don't have the money or the resources, say so, and your voters can try to get you more resources. If you really don't like cows and you don't think cows matter, well, then say that, and your voters can take that into account. And if the law just doesn't support the charges, say that, and the court will back you up. At the end of the day, it's about being transparent, because each of you listening ultimately are the people in whom the prosecutory power resides. You transfer that to your elected agents, and it's on all of us as attorneys to try to make this system as equitable and just as we can. And I will leave you with that. And please do write in. I know that we've got a lot of comments, and in particular, I know a lot of you had thoughts for Will, and I know he has more for you. So we'll try to get you all connected.
Thank you so much, David.